Welcome back to Law&Crime Daily, everybody. An interesting court battle is underway in Tennessee following a shooting in March at a Christian school in Nashville. Multiple groups want a judge to decide if some of the shooter's writings should become public. Audrey Hale opened fire inside the Covenant School, killing 3 children and 3 adults. The Metro Nashville Police Department denied open records requests for writings left behind by the shooter who was killed by police. Now, the National Police Association and Tennessee Firearms Association are suing the police. The groups say there could be information in the writings that could benefit public safety. But opponents, including the school and many parents of students there, point out that copycats could be inspired by what this shooter wrote down. Well, now it's up to a judge to decide if the documents, which include a journal and suicide note, should be released. So, Mike, does the judge only have 2 choices here? Release it all or release none of it?
No, the judge can actually go down the middle, I believe, in this instance, is where he could do it where he retracts certain parts that he think could be prejudicial or harmful, so give a retracted release until a further decision. It's a very difficult decision because the safety of people are at risk, but once it becomes a criminal investigation, at some point in time, that becomes public records in preparation for a defense.
You know what's interesting, and Brian, as I mentioned, many of the parents, the Covenant School, growing movement, they don't want the notes released. And I think in a day and age where we keep seeing school shootings and mass shootings, there's a legitimate argument that you don't want to invite copycats because sometimes these shooters are looking at past shootings for inspiration. So could they win their case here and not get it released?
I mean, Jesse, I think it's more than a strong argument. I think we have the actual writings of the Parkland school shooter. And so I think the argument to say that these writings should be released so we can learn more from them is 100% valid. But I think, as Mike said, the judge can kind of split down the middle and say, okay, but you, these gun right lobbyists, don't need the information. Have you ever used this information to try to cut back on these school shootings? Has anyone ever used this information to do so? So why this one in particular? And if he does end up doing as Mike said and kind of going down the middle, okay, give it to the people who are researching ways to stop this, and the rest of the public don't need it. Because I do think, especially when you look at things like the Parkland school shooting and others who drew swastikas on their clothing and promoted other shootings, try to draw attention to themselves, we see, as you said, that there are many copycats, and I think the dangers far exceed the benefits in this situation.
Okay, we will see what the judge ultimately rules. Well, another big story making headlines right now. Police in Rhode Island arrested a city councilman, charging him with drug possession. When an officer approached Matthew Riley's car around noon on Monday, Riley was passed out with a crack pipe and lighter in his hand. Body cam footage captured the moment that the officer realized that the man in front of him was an attorney and city council member.
Roads open,
You're gonna stop, try not to Oh, no way, dude, really?
Yes, yes. I was just on my way back from court.
Bro. Well, a rescue's gonna come check you out, man. I can't let you go. You were literally choking in your sleep. Somebody flagged me down about it.
Oh, I have sleep apnea. I'm sorry.
Well, and then you have a crack pipe in your hand, so it's like...
Wait, sorry.
Listen, I have a body camera. Obviously, everything I have is recorded. You know that, and what I've observed is on camera, so I can't pretend I didn't. You know, so a rescue's gonna come here, and they're gonna check you out. You know, as far as I know, there's no drugs anywhere, so I can't. You know, so there's not a criminal investigation. There's more a health or well-being check type thing.
Thank you.
Yeah, I obviously have to document it. You know. You can have that back.
Thank you. There will be no arrest.
What?
There will be no arrest?
No. Are there any drugs in the car or anything like that?
No, nothing.
All right. How long have you had this problem, man?
It was a relapse. I've been clean for 13 years.
All right.
Just went through a really, really bad divorce recently.
Okay. Do you know if any of that was laced with fentanyl or anything? Because you were out, and looked like you were choking.
Really?
Yeah. That's why somebody literally sprinted and flagged me down because they thought you were having a heart attack or choking.
No, not that I know of.
And guess what? The drugs did test positive for crack cocaine and fentanyl, and Riley did end up getting arrested. He He has since resigned his position on the city council and has entered a drug treatment program. And we're finishing today's show out in Michigan, where the parents of the Oxford High School shooter are fighting to stay out of a courtroom on involuntary manslaughter charges. The shooter entered a guilty plea to murder and terrorism charges last October after killing 4 people and injuring 7 others in November of 2021. Prosecutors accused the shooter's parents, Jennifer and James Crumbley, of ignoring several warning signs shown by their son prior to the attack. Examples include the Crumbleys gifting their son the murder weapon for Christmas and dismissing concerns from school administrators about his behavior. The decision to send his parents to trial made it to the Michigan Appeals Court, but appeals judges ultimately sided with the prosecution, letting the shooter's parents go to trial on 4 counts each of involuntary manslaughter. Now, the Crumbleys' defense team is trying to take the case to the Michigan Supreme Court and away from a criminal trial. In Thursday's filing, they called the appellate decision, quote, clearly erroneous, saying it will cause injustices and conflicts within the Michigan court system. It's unclear if the Michigan Supreme Court will hear the case, but here's a portion of the appellate hearing that could be rehashed in a second set of arguments.
James Crumbley had no knowledge of what EC was planning.
He was called over to the school that day, wasn't he?
He was.
He had knowledge then.
He had knowledge that there was a drawing, but had no knowledge of what EC was planning to do that day or at any other point.
Certainly a warning signal, wouldn't you say?
It could be a warning sign that EC may have been troubled or may have been having certain thoughts, but not a warning sign that he was going to kill 4 other people.
Warning.
Go ahead.
Sorry, warning sign that maybe he had access to a gun?
James Crumbley did not know that EC had access to that firearm.
He bought him the gun.
Well, and the first thing he did when he heard about the school shooting was go back home to see if the gun was there. So certainly was on the top of his head.
The school district or the personnel there equally as culpable as the parents, as Ms. Smith said?
I would push back on that and say no. First, I would disagree that they had the same level of knowledge. These parents knew more, such as he was gifted that gun days earlier, that it was considered his.
No,
that he was
having a gun, there's nothing illegal for parents buying a gun for their children.
There's not, but it is.
And the school district even said it's a fine hobby.
It is.
Just don't bring it to school.
It is.
You also charged EC as an adult. Should that factor in? You consider him as an adult, the Oakland County Prosecutor's Office, the state considers him an adult. Should that factor in our decision here?
No,
he's not a child. You're calling him an adult.
I love listening to the judges play devil's advocates for both sides, but if focusing on the Crumbleys for a second here, Mike, do you think there were any additional arguments that they should have made in the appeals court that would have helped them and maybe they need to consider moving forward?
That's a tough question because this case has so much unclear and new kind of issues to it. And it really moved, like you said about that judge. That judge really gave the vibe that his first time in the courtroom was as a real lawyer because he asked very fair and open questions that showed he wasn't really favoring one side or another. So I think this is going to be a case that's really going to see how it unfolds during the appeal process because it's a very unusual issue.
Well, Brian, let's break this down. So hearing both arguments and hearing Mike had to say, do you think that the state Supreme Court judge should ultimately take on the case? Because I'll give you my perspective real quick. I think this is going to have ramifications, not just for the state of Michigan, but for the rest of the country. This is going to be very important and maybe would set a precedent moving forward about the liability of parents who need to take a second look and not facilitate their children having weapons and facilitate these kind of school shootings. This may be a wake-up call for parents moving forward, not just charging the Crumbleys, but if this actually goes to trial and they're convicted. So let me ask you again, do you think, based on everything we heard, that the state Supreme Court judge should take on the case?
What I think the state Supreme Court will do and probably should do is wait for the appellate court's decision. Supreme Courts take on cases for a number of reasons. The 2 largest ones, I think, are if the lower court got it wrong and they want to correct a mistake, or if they want to establish a bright line rule. I'm not sure whether or not the appellate court got it wrong from the questions and the way they're peppering both sides. I think they did get it right. I think they should be going towards prosecution and certain factors can lend towards involuntary manslaughter and not. But I do think the state Supreme Court could step in and create a bright line rule saying these factors can lead a parent to being charged with this crime, and these factors can disqualify them. Because I think not only for the state of Michigan, but for the entire United States, a bright line would be very helpful.
You might be right. We will see. Brian, Mike, thank you both so much. Everyone out there, thanks for joining us here on Law and Crime Daily. We're going to see you next time as we discuss justice in America.